So welcome, everybody. It's so great to have you today. Jeff Rosen, I'm the president and CEO of the Constitution Center, is here, and my name is Kerry Sautner. I'm the Chief Learning Officer at the National Constitution Center today, and we are going to go through voting rights in America. This is an amazing topic and one that is going to walk us, it's like a walkabout on the entire Constitution. And so we're so glad our top scholar is here to walk us through the Constitution, tell us the history of how voting rights in America has ebbed and flowed over time, and then talk about some current conversations around voting rights, and even maybe dive in some no excuse absentee ballot hypotheticals. Jeff, do you think we can do it all in 30 minutes?
Absolutely. I can't wait. Let's give it a shot.
Okay, go. Let's get started. Would you like to start with the big kind of questions for today? Here are the big questions that have come in. So what does the original Constitution say about voting rights? How did constitutional amendments change or transform the Constitution's relationship to voting? And what are the relative roles of the national government and the state governments in this context? So a lot to go through, and I know you always like to start with the Constitution. And let's be honest, if you want to screen share, look at that Constitution we have to go through today. It might be a great day to screen share the interactive Constitution.
You're reading my mind. That's exactly what I wanted to do, and I can't wait to look at the major voting rights provisions of the original Constitution and see what the interactive Constitution has to say. Friends, remember, the interactive Constitution has essays by America's leading liberal and conservative scholars about every clause of the Constitution. So it's going to be so meaningful to see what they have to say about Article 1, Section 2, 3, and 4. That's the place to start, because that's what the original Constitution had to say about voting rights. After we've talked about those, I'll pause for a breath, and Kerry and I will talk, and we'll take your questions, and then we'll run through the major amendments that had to do with voting rights passed after the Civil War, in particular the 14th, 13th, and 15th Amendments, as well as the 19th, which gave women the right to vote, and subsequent amendments lowering the voting age. Okay, so let's get started. Article 1. Article 1, Section 2 is our first provision. Let's see what our scholars have to say. So this is the provision that has to do with voting qualifications for the House. And our scholars, Brad Smith and Daniel Tokai, note that not all people were eligible to vote at the time of ratification. Article 1, Section 2 sets out the qualifications for voting in U.S. House elections. They're the same as voting in the larger branch of the state legislature. So if you can vote for your state house, you can also vote for the U.S. House. That excluded, at the time of the founding, women, as well as many free African-American and Native Americans. It took the 14th and 15th Amendments to enfranchise African-Americans and the 19th to enfranchise women. Also, some white men were barred from voting by property ownerships, which was the norm in 1787. There was a debate about property ownership, and the compromise tied qualifications for voting in the House to those for state legislatures, allowed about 2/3 of white men, but few others, to vote. Still, this is significant. We shouldn't judge the framers entirely by our own standards, because this was far more expansive in allowing people to vote than was the case under English law, and states expanded this suffrage for white men in the Jacksonian era. There are also a bunch of qualifications for serving in the U.S. House in the Constitution. We know the main one. You could chat it if you liked. How old do you have to be to serve in the House? Well, you can read it now, but here it is. You have to be at least 25 years old. You have to have been a citizen for 7 years and an inhabitant of the state for which you're selected. Congress can't add to those qualifications. That's Powell and McCormick in the term limits case. Powell and McCormick, friends, was one of the first cases I studied in law school. And the question is whether the House could expel someone because they thought he had done bad stuff. And the idea was that the House was adding to the qualifications for service, and that violated Article 1, Section 2. And then there are relatively brief elections. Every 2 years, you have to go back to voters, unlike the Senate, which we're going to look at in a minute, which has 6-year terms. And then the court uses the requirement that the House members are elected by the people of the several states to say that every congressional district has to have equal population. That's the Westbury and Sanders case, and one person, one vote. All of that was under the 14th Amendment. And then this is really relevant. Article 1, Section 2 requires an actual enumeration of people every 10 years. That's the census. Friends, just I think on Friday, the US Supreme Court agreed to decide a really important case involving the census. And that's the question, can the president, in this case, President Trump, have census figures that exclude non-citizens who are in a state illegally? And he says he can, and the people on the other side say an actual enumeration of persons has always been interpreted to mean citizens and non-citizens, and it's a violation of this enumerations clause to exclude non-citizens. Hugely important case, and the Supreme Court will decide it later this year. We have the infamous 3/5 clause, which we talked about earlier, saying that states' direct taxation and representation is determined according to the whole number of free persons and 3/5 of all other persons. Everyone understood that meant to exclude slaves, so that enslaved people couldn't be counted for the purpose of the census, but be denied the vote or taxation and so forth. And then we have the House having the sole power of impeachment, and the Senate has the power to try impeachments. Okay, I'm going to pause, Kerry. I think it's really helpful and interesting to actually read what the Interactive Constitution has to say. Questions or thoughts before we move on to the Senate?
I think there are a few, but they're mostly around kind of who gets the right to vote and how does that change over time. So I think we should go through the structure, the original Constitution, and ask that question. How does the original Constitution define voting, and what parts does it define? And then I have like 3 already coming at you for who gets to vote and how does it exactly work. So lots of fun hypotheticals in this one, and some real good ones that might be coming down the road soon.
That sounds good. But friends, the first thing we learned from Article 1, Section 2 is who gets to vote for the House? Anyone who gets to vote for the largest house of the state legislature. That's the answer of the original Constitution. That excluded, at the time of the framing, in most cases, African Americans, although some free African Americans could vote at the time of the framing, despite what Chief Justice Taney said in the infamous Dred Scott decision. And women, in most cases, do not have the franchise, although in New Jersey they did. So even at the time of the framing, a few states allowed women and free African Americans to vote, but it took those later amendments to expand the franchise. But broadly, we have this important rule that it's the people who can vote for the largest house of the state legislature. Okay, time for the Senate. This is so interesting to read Steve Calabresi and Michael Gerhardt. Steve Calabresi, the founder of the Conservative Federalist Society, Michael Gerhardt, scholar in residence at the National Constitution Center. They're both agreeing on every word in here, so we can make sure, we can be sure that it's like canonical. And what both Michael Gerhardt and Steve Calabresi tell us is that they viewed the Senate as counter-majoritarian. In other words, they're suspicious of popular majorities, and they want to frustrate direct democracy to check the House. They think that the People's House might be full of passions and full of unreasonable populist excesses. And therefore, they wanted a Senate where senators are originally chosen by their state legislatures and subject to instruction and recall if they don't do what their legislatures tell them to do. So basically, they're confident that state legislatures will keep a check on senators and ensure that they are not misled by the excesses of the people. That, of course, changes with the 17th Amendment, which eliminates Senate election by state legislatures and ensures popular election of senators. Also, the most important feature of the Senate, every state has 2 senators, regardless of how big it is. A small state like Delaware has as many votes as a large one like New York. That's the less small states are supposed to be able to protect themselves from having their interests overrun by the large states. Then we have longer terms. How old do you have to be a senator? 30, 25 for the House, 30 for Senate. And how old to be president? You remember from last week? 35. It's easy to count up. You got to be 5 years older for each increasingly weighty office. And the higher minimum age requirements and longer Senate terms, 6-year rather than 2 years, are designed to increase the likelihood senators are better educated and more disposed than their House counterparts to take the long view on important issues. Friends, it's very sobering to contrast the framers' Senate with today, which is so riven by political parties that it's a more majoritarian body. And the big debate nowadays is whether to eliminate the filibuster. broadly, the filibuster requires that you get 60 votes in the Senate before you can close off debate. That's called cloture. And that generally, although not always, means that you need 60 votes to pass important legislation, although there are some exceptions like financial bills and the tax bill, which can be passed by something called budget reconciliation or simply 50-vote majority. There is a debate. Some Democrats have proposed that if Vice President Biden wins the presidency and Democrats take the Senate, then they will consider eliminating the filibuster so that the Senate, like the House, is a purely majoritarian body that can pass anything by 50 votes. That's a good question for you to debate in your classes, whether you think it would be a good or bad idea to eliminate the filibuster. But we learned from our scholars here that it's different than the framers' original hope that the Senate would be a sober, thoughtful, counter-majoritarian body that would rise above partisan interests and would represent the public good as a whole. And then we have a bunch of things that the Senate can do, 4 things that without the House: advice and consent to presidential nominations, ratifying treaties, conviction and removal of high-ranking officials for misconduct, and approving constitutional amendments. Those are all supermajority votes. That's 2/3 votes rather than 51 votes. And that's all designed, as James Madison says, as a shield to some particular interest and another obstacle generally to hasty and partial measures. The essay concludes by noting the 17th Amendment, which allowed direct election of senators, which weakens the connection between the senators and their states, and notes that some scholars have said that this led the Senate to join the House in expanding to unprecedented degrees the size and scope of the federal government at the expense of state sovereignty. All right, there's the Senate. One more, Kerry? Should we do Article 1?
Yeah, one more, and then we're going to do a poll.
Okay, sounds good.
Because you know how I like polls.
I'm learning a lot from the refresher of these wonderful essays. And friends, whenever you're not sure about a clause, just go to the Interactive Constitution, read the main common essay. And remember always, we're not reading them now because we don't have time, but there are matters for debate on each of these essays where our different scholars give their areas of disagreement as well as agreement. Okay, so the Elections Clause, the main source of constitutional authority to regulate elections for the House and Senate. It allows states to determine the time, places, and manner of congressional elections, subject to Congress's authority to make or alter state regulations. So that's the answer to the third question that Kerry began by posing. What's the balance between federal and state authority? Well, states can determine the time, place, and manner of elections, but Congress can make or alter the state regulations. So Congress has the ultimate authority. It gives every level of government the authority to enact a complete code, including public notices, voter registration, voter fraud, voter protection, voter counting. We're about to have an election. Every state's going to have a different rule for how you submit ballots, how you count ballots, what your deadlines are for ballots. That's all because of the Elections Clause, which gives the primary responsibility to determine the time, place, or manner of elections with the states. Still, Congress can pass federal laws that preempt or displace contrary state laws because the framers are concerned that states might establish unfair election procedures or refuse to hold elections for Congress. Congress has sometimes exercised this power. There's a single national election day. That's a federal statute that establishes the beginning of November, the first Tuesday in November as a election day. Congress could change that statute, but as long as that statute stays on the books, remember that question a few weeks ago, can the president delay the election? No, he can't. No, he can't, because the Elections Clause says that Congress has the ultimate authority to make or alter rules concerning congressional elections, and there's a federal law in the book about Election Day. Also, this tells us that this is a really important provision. Congress has mandated states with multiple representatives in the U.S. House divide themselves into congressional districts rather than electing their representatives at large. That sounds really technical, but that was an 1848 or so statute. Without that law in the books, then Congress could, or rather a state could say, we're going to elect all the representatives from New York at large. So that would mean, say, I don't know how many representatives New York has. I'm just making this up. Say it has 10. I'm sure it has a lot more. Everyone in New York could vote for all the 10 candidates. That would mean that New York City, which has many more people than upstate New York, would probably elect a lot more of those 10 representatives than is the case if each state is divided into congressional districts. It also means that proportional representation, which weights the relative intensity of people's preferences, can't be taken into account because congressional districts generally require winner-take-all systems, and that very much is a contributor to political polarization. Congress also has elected laws limiting the amount of money people contribute to candidates for Congress. Those were the laws that were, some of which were struck down in the Citizens United case, requiring people publicly disclose most election-related spending. Voter registration forms have to be available, and ensuring the accuracy of elections. Now, states cannot enact laws, nor can Congress, that violate other constitutional provisions. Remember, we just said in a second, anyone who's eligible to vote for the larger house of the state legislature can vote for the House and the Senate as well. States can't override that by establishing additional qualifications for voting, by saying that you have to pass some special test, for example, that would violate the elections clause, as well as arguably the 14th or 15th or 19th Amendments. And then we have the 14th Amendment, which the Supreme Court has construed to protect a fundamental right to vote that bars states from imposing substantial burdens on the right. So when you have laws that say you have to satisfy requirements or follow procedures, then the courts ask, is this a reasonable regulation of the electoral process, or does it undermine the right to vote? And so many of the controversial questions before the Supreme Court now, like, can you vote in advance, or do you have to vote in a assigned polling place, or can you get an absentee ballot? Many of those questions are litigated under the 14th Amendment. Finally, we have age and residency requirements for the House or Senate. You can't add to those, but you can have reasonable ballot access restrictions. The Supreme Court has struck down term limits on members of Congress. That was a 5-4 decision, saying that the election clause doesn't allow the state to refuse to print on the ballot the names of candidates who'd served 3 terms. And then there are implicit limitations on congressional election regulation. You can't favor or disfavor certain classes of candidates by placing a warning on the ballot and so forth. And then finally, we're still going because it's so important and interesting. And I'm always learn a lot when I review this. The election clause does not give the power to regulate congressional election on the state as a whole, but on the legislatures of the state. The court has construed that broadly to include referenda. So even if you pass an initiative or referenda that allows, for example, certain restrictions, the court says that, like a legislature, that power cannot be limited. And then finally, a legislature can delegate its authority to other entities, such as independent redistricting conditions. The whole debate over partisan gerrymandering, which is when states draw their districts to look really funny to ensure that incumbents get reelected. One way to get around that would be to create independent districting commissions, and the court has said that legislatures can delegate their authority to those commissions, although that's disputed on the Supreme Court, and some justices disagree with that holding. All right, Kerry, we got through the 3 major original clauses of the Structural Constitution, Article 1, Section 2, 3, and 4.
Awesome. Okay, so when we think about the original Constitution and we look at that, there is so much in there that really is spelling out how voting should work. They don't particularly go other than if you can vote for this, you can also vote for this. Are they when the Founding Fathers are writing the original Constitution, are they hyper concerned about who can vote or more concerned about representation and how the system works? So one big picture question on there, and then we're moving to amendments.
They're mostly concerned about representation. In fact, the very first amendment that James Madison proposed to the Constitution, and Kerry and I know this because we can look at one of the original copies of the Bill of Rights, which we have at the National Constitution Center. The original First Amendment was not the one that says Congress shall make no law abridging freedom of speech. It said that there would be an enumeration in Congress every certain number of years, and 1 representative in Congress for every 30,000 inhabitants. If that had passed, there'd be something like 6,000 Congress people today. Luckily, it didn't pass, but that shows that that's what the framers are really concerned about. How many people is each congressperson going to represent? They're concerned about the closeness between representatives and the people. They want the districts to be big enough so that Congress doesn't get too big, but small enough so that representatives are actually responsive to the people. They're thinking less about qualifications because they've already settled that by answering that by saying that if you can vote for the largest house of the state legislature, then you can vote for representatives in Congress. It's up for the states to decide who can vote, whether women can vote or African Americans can vote. That's not something that the framers were centrally concerned about. They were more concerned about the nature of representation.
Which is fascinating. And then the amendments themselves, as they come through, they start to look at who can vote. Now, real quick before we get there, Colin did have a question. Could a state, and this is years ago, originally, could a state say that you had to be a certain religion to run for state senate or the House of Representatives? Could a state make that election mandate in the state?
I think, Colin, that we can find the religious test clause, which will answer that question. And the Constitution says that there shall be no religious tests that are imposed as a condition of serving. So let's find it. And we know that the no religious test clause, it's so cool. I just Googled it and because I knew that that was the fastest way to do it. And the interactive Constitution came up first. I'm so pleased to say. So if I stop sharing and now do you have it here? Article 6. Yep. This is so cool. I'm so glad that everyone is checking out the religious test clause from the interactive Constitution. It says, first we'll look at here we go. The senators and representatives shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be. I'm trying to get to the bottom of the screen so I can find the final language. There we go. Shall ever be required as a qualification to any office. And then we have this great essay on the no religious test clause, which says any office or public trust under the United States. And this bans a longstanding form of religious discrimination and provides a limited but enduring textual constitutional commitment to religious liberty and equality that's influenced the way Americans have understood the relationship over the last 2 centuries. Friends, isn't this incredibly useful? I mean, I had to look to the interactive Constitution to find the exact text of the religious test clause language. And then we have this wonderful essay by Alan Brownstein and Judd Campbell that will provide an answer to Colin's question. So there we go.
Okay, so real quick to jump into the amendments, and we're going to do this really quickly. I'm going to launch a poll. So I don't know if you have to stop sharing, but let's see if it works. So let me know in the chat if my really fun, fast and furious poll is able to be seen. So open up your chat and just let me know if thumbs up, you can see it, and then you can start answering the questions. So, and then Jeff, you're going to be you have to tell us which one's right. So this amendment, ratified in 1870, says the right to vote cannot be denied based on race. This bans racial discrimination in voting. Which amendment is it? Is it the 13th Amendment, the 14th Amendment, or the 15th Amendment? If you can't see the poll, you can also answer in the chat. The second question is, this amendment, ratified in 1920, grants women the right to vote. Which amendment? We got brain trust here. Which amendment is it? 12th Amendment, 17th Amendment, or the 19th Amendment? Very good. They're flying in. And the final question is, this amendment ratified in 1965 ends poll tax in national elections. Which amendment is it? Is it the 24th or the 26th Amendment? That one's a little harder. And so they got easier and harder. So, okay, first, Jeff, as people are still answering, this amendment ratified in 1870 says the right to vote cannot be denied based on race. Can you tell us the 13th, 14th, and 15th Amendment, which one it is, and then walk us through those 3 Reconstruction amendments really quickly?
Yes. Well, it's great that our friends are getting the right answer. Nearly 60% say the 15th Amendment, and that is correct. Now, those who answer the 14th Amendment, though, get a lot of empathy here because the Supreme Court today regulates most voting rights questions under the 14th Amendment, not the 15th Amendment. And it's a complicated story about how that happened. But it's in fact the 15th Amendment that says that the right to vote shall not be abridged on account of race. And that is the correct answer. Now, summing up the 13th, 14th, and 15th Amendments, I teach an entire constitutional law class on the 14th Amendment. So there's a whole lot to say about it. But when it comes to voting, I think the main thing you have to know is that the original 14th Amendment was only intended to cover civil rights, but not political rights. Civil rights were rights that you could take from state to state. In other words, if I'm in New York and I go to Virginia, I can make contracts in Virginia. I can sue and be sued in Virginia courts if I break contracts or if I commit torts or so forth. But I can't vote in Virginia elections, or I can't serve on Virginia juries, because voting is a political right, not a civil right. But over the course of time, in particular in the 1960s, the Supreme Court began to say that the right to vote is a fundamental liberty that is protected by the 14th Amendment. And so much of our current voting rights jurisprudence, including all those cases I said that have courts evaluate whether or not voting restrictions are reasonable or not, are all settled under the 14th Amendment today. Hard to reconcile with the original understanding of the amendment, but a whole series of cases accepted by both liberal and conservative justices. So that's why there's so much action under the 14th Amendment of voting rights today.
So next question is the amendment that's ratified in 1920 that gives the women the right to vote.
Okay, well, this is so important, and we're getting 95% correct, and it is indeed the 19th Amendment. That's an important one to get because this is the 100th anniversary of the 19th Amendment. It was ratified in 2020, rather in 1920. This is 2020, 100 years later. The National Constitution Center has such an exciting new exhibit on the 19th Amendment. If you can't come to see us in person, which I know is tough these days, you can see a lot of it online, and it's really inspiring to see the struggle of how women won the right to vote.
So Andrew had a question earlier that's kind of wrapped around these. Most of the time when people were disenfranchised, like even when you go from, African-American men originally in Vermont could vote, and then they were no longer able to vote, women in New Jersey. And then over time, you watch this kind of pullback on people's right to vote, and then these amendments come through. So Andrew's question was it the federal government that was disenfranchising, or was it the state governments that were disenfranchising people during different time periods?
Great question, Andrew. And the answer was the states, because the states are the ones who have the total power to set qualifications unless Congress steps in. And Congress didn't step in. It basically allowed states to disenfranchise women and African Americans and failed to do anything about it. So it was the states, and it took the federal government in the form of the 13th, 14th, and 15th Amendments finally to step in. And after the Civil War and say, hey, states, we've had enough of this. You can't keep disenfranchising people. Now, the great tragedy of Reconstruction is that the 15th Amendment, which granted African Americans the right to vote, didn't explicitly ban literacy tests, poll taxes, and all sorts of other ruses that the states would quickly use to disenfranchise African Americans without doing so explicitly. In other words, in the South, they didn't say, hey, African Americans, you can't vote. They'd say, you got to take this test before you can vote. And that made it really hard and white people didn't have to take the test. So as a result, lots of African Americans couldn't vote. Early drafts of the 15th Amendment, you can see on the Interactive Constitution, would have prohibited poll taxes and literacy tests, but they didn't pass. So because the final 15th Amendment that passed was relatively narrow, it just said no formal disqualifications on the right to vote. We had to wait more than 100 years for the passage of, and this leads to our next question, which of another constitutional amendment in 1966 to end poll taxes in national elections. And which amendment is it? Absolutely, 75% of you correctly say it was the 24th Amendment. The 26th Amendment is the one that has to do with the creating the right to vote at age 18. So that's important as well, and is another right to vote amendment. But poll taxes were the 24th Amendment. And if we want to quickly screen share, we will learn that on the Interactive Constitution, here we go.
Make sure you can do it. Yeah. I'm like, end the poll.
Absolutely. The right of citizens of the United States to vote in any primary or other election for president or electors or senator or representative shall not be denied or abridged by reason of failure to pay poll tax or other taxes. A kind of fun fact or trivia fact, I don't know how fun it is, but it's interesting. I think of poll taxes meaning you pay a tax at the poll when you vote. In fact, poll means head. It's an old English term that means head. So a poll tax is a head tax that you pay when you show up at the voting place. Each head or each person is supposed to pay the tax. But they're very discriminatory because if you're poor, you can't pay the tax. So it took the 20 Fourth Amendment to ban those taxes, and that was ratified in 1966.
Okay, now two questions from the crew around these two amendments. So 24th is poll tax. So Colin's question was, wouldn't a law requiring former felons to pay fines and fees violate the 24th Amendment? In some way, could that be considered a modern poll tax if felons had to pay to vote?
Wow, what a great suggestion, Colin. I love the way you're thinking. And that kind of creative translation of the text of amendments passed for one purpose, namely the narrow purpose of abolishing poll taxes, to an unforeseen situation like felon disenfranchisement is the sign of a really creative constitutional lawyer. So great job. I don't believe, without knowing this, because I haven't studied it, that courts have bought this argument. I'm not even sure that any lawyer or law student has made the argument. If you were in law school right now, I'd encourage you to write a law review article about this, to kind of research the original understanding of the poll tax amendment, look at the case law, and basically make an argument, like you were writing a brief, to say why you think that the 26th Amendment, or rather the 24th Amendment, should be expanded in just this way. But as I say, I don't think that it's been so construed. And just a few weeks ago, the Supreme Court refused to review an appellate decision saying that felons could be required to pay off their fines before they could vote. And the court rejected the idea that that was an unconstitutional burden on the right to vote.
Okay, so one last final question, and we're trying to jam in a lot. This is really fun. This came from one of our students, and they want to make sure they're studying this in class so they understand the Voting Rights Act of 1965. So you said the tragedy of the Reconstruction period is almost in the writers knowing that some of these things could happen, but then it not passing fully, and then there was a poll tax. And it takes almost 100 years for Congress to enforce the voter discrimination that we see through the Jim Crow laws, through the literacy test, through the poll tax. So can you tell us a little bit about the Voting Rights Act of 1965 so our students have an understanding of how that shifted the ability to vote and re-enfranchise people?
It's so important. It's one of the great statutes of the 20th century. And it was passed by broad majorities and signed by President Lyndon Johnson. And it creates a federal law saying that the right to vote can't be abridged on account of race. It included lots of requirements, such as the fact that states that wanted to change their election procedures or make it harder to vote in ways that affected minorities would have to get permission from the federal government before they could do that. That's called federal pre-clearance. Now, there's a lot of really interesting and important debate about how long Congress was allowed to require states that had discriminated in the past to continue to seek pre-clearance. In the Voting Rights Amendments of 2006, Congress, by a broad bipartisan majority and a law signed by President George W. Bush, said that the pre-clearance requirement should be extended, and states that had discriminated in 1965 should still have to get pre-clearance because of the lingering effects of discrimination. In the Shelby County case, the Supreme Court, by a 5-4 majority, struck down those pre-clearance requirements of Section 4 of the Voting Rights Act as amended in 2006 and said, no, it's been long enough. There's no evidence that these states are continuing to discriminate, and therefore you don't have to get approval from the federal government. In a very strong dissenting opinion, Justice Ruth Bader Ginsburg and the liberal justices said there was extensive evidence that Congress had considered when it renewed the pre-clearance requirements, and therefore the court was wrong to strike those requirements down. So that's just to give you a sense of the fact that debate about the scope of the Voting Rights Act continues vigorously. It's important in cases before the Supreme Court. And you can read the Shelby County case, read the majority opinion and the dissenting opinion, and make up your own mind about who you think is right.
I think that's a fantastic way to wrap it up. There's a lot to dive in here and a lot to look through with the Voting Rights Acts, as well as voting in America with all the amendments and all the pieces we look. So I wanted to thank you very much, Jeff. I know there's a few more questions coming in at the end, so we'll wrap up class. Thank everybody for a great class, and we will see you next time in class. We're hosting this class again on Wednesday at 12 and 2, and on Friday at 1 o'clock, we have a very special guest, Jamil Bowie. So it should be a fascinating week looking at voting rights in America And just think how many great conversations you can have at your dinner table after having this class. You'll be ready to go, ready to jump in. So very fun. Thank you, Jeff.
Thank you, Kerry.